Hello and welcome to another edition of Coffee Talk with Immigration Attorney Brian D. Lerner. In this particular video we will be talking about the update in the DACA. That's the acronym which now is being used, which stands for Deferred Action for Childhood Arrivals, otherwise known by many people as the DREAM Act or for the Dreamers. It is now available to prepare the petition, to submit it, and to get an answer. And so I've made other videos on this subject. This is really an update on those particular videos. We now know what forms need to be prepared. We know the filing fees are going to be about $500, and we know several other things. Now, just to give you a background update on the matter, in order to qualify for DACA, DACA, there's a few elements which really haven't changed since the initial introduction of this particular program. There's been some qualifications, there's been some further explanations, and so forth, but the basic requirements are the same, and I'm going to go over those in a minute just to repeat and make clear. But then I'm also going to discuss some matters which, through the question and answer periods that they've had, through the information channels that they've provided, and through other manners of obtaining the information, we have determined so that you will be more of have a better idea of what needs to be done, how it should be done, and then where it would be submitted. Now, the first item is that you have to have arrived in the U.S. While you were under the age of 16. This is really a non-negotiable. It's not gray at all, meaning that with some of these requirements, there's ways. For example, if you were to come into my office, I'd be able to let you know, well, okay, we need to do this and that to get you under this particular requirement and so forth. This is one that's pretty much set in stone. So if you came to the U.S. While you were over the age of 16, you're for sure not going to qualify. Now, there is a little ambiguity here where it says under the age of 16. Does that mean if you were 16 and came here that you would still qualify, or do you have to be 15, 12 months and 29 days or under? So that's the only ambiguity I see there. At first blush, it does seem to state that you are have to be actually under the age of 16, although we would discuss whether or not we should go forward if you were exactly 16 at the time of entry. Now, the next element is that you have continuously resided in the U.S. for at least 5 years prior to June 15th, 2012, and have been present in the U.S. on June 15th, 2012. So, a couple things that we can discuss with this requirement. If you were previously deported, or if you took a vacation day, or if you left the United States, whatever the item or element is whereby you were not physically inside the United States on June 15th, 2012, you're not going to qualify. So there might be other ways and other manners which, in other types of petitions, which you might be able to go forward and which might be able to help you. But as far as DACA is concerned, this is pretty much set in stone too. The second part of what I just told you, that you have to be inside the U.S. on June 15th, 2012. Now, the prior element, the prior part of this element, that does have some, what I refer to as gray area or wiggle room. You have to have continuously resided for at least 5 years prior to June 15th, 2012. So the question is, what does continuously resided mean? What happens if, for example, you did leave before a certain date and you went and saw your mother back in Mexico or the Philippines for a week or 2 weeks or a month. Or let's say that you left 3 times for a month, or let's say that you left once for 4 months. Does that break the continuous residence requirement of 5 years? Well, there's been some discussion from immigration on this matter. There's been some back and forth question and answers. And the bottom line is that they're going to essentially analyze each particular case individually, but it seems to be that if you left for what they refer to as a short time and then came back, whether you came back illegally, whether you came back in another manner, it won't seem to break the continuously, you have continuously resided in the U.S. for at least 5 years. So while I'd have to look, if my office was preparing it, I'd have to look at the specifics of this particular item. Don't just think because you left for a certain period of time within that 5 years that you're no longer eligible. Or if you left and you came back illegally and let's say, for example, on other areas of immigration law, by coming back illegally, you'd be subject to what is referred to as the permanent bar, and you couldn't even file for a waiver of that bar for 10 years. However, DACA is different. It's a different animal that we're dealing with here, so that won't kick you out of qualification. And of course, the interpretation of what is a short visit is that's up for interpretation as well. But this certainly gives some wiggle room in order to argue that you do qualify under it. Now, the next element is you have to currently be in school, have graduated from high school, have a GED, or be honorably discharged from the U.S. Coast Guard or the U.S. Armed Forces. So there's also some questions on this matter. I've had lots of people call and say, well, they left school when they're in 11th grade or 10th grade, or they didn't go to high school, and do they qualify, and so forth. And in this particular regard, let's say that they were not honorably discharged, and they are not in school and have not graduated or received a GED. Well, in this regard, let's say they qualify for all the other items of DACA except that. Well, this is relatively easy to fix. That person can take the GED and pass it. That person can go back to school, just get accepted into a night school and start going. Go to a community college. So there's ways of working around this element so you do qualify. So if for whatever reason you don't qualify for this element, then by far this is probably the easiest one to fix or to get into the qualification arena once you take care of it. So again, the message I'm trying to convey here is that you do not have to necessarily qualify for each one as of right now, but if you come to me for a consultation and we move forward, I will suggest what you can do in order to proceed, okay, in order to get you in a better position so you do qualify. Okay, so the next element is that you have not have been convicted of a felony offense, a significant misdemeanor offense, or 3 or more non-significant misdemeanors, or otherwise pose a threat to national security or public safety. Well, I'm going to assume that anybody that calls me or comes in my office isn't going to be pose a threat to national security or public safety. They're basically going to run the names through a database in that regard and see what comes up, and if something does come up, then it's a matter of dealing with it at that time. But the question then is, what is considered to be a felony? What definition does it go under? And for purposes of DACA, they've essentially defined felony as where the sentence of imprisonment is more than a year, and so forth. Now, there's different definitions for what is a federal felony, for a state felony, and if you have a felony, that's going to kick you out of DACA right away. But it is possible to do criminal relief. So let's say, for example, you have a particular crime, and let's say the sentence was 16 months. Well, clearly that would be a felony under this standard. So let's say we do criminal relief. And criminal relief is when we go to criminal court and we try to vacate or reduce the crime because of all kinds of different reasons. But let's just say you pled guilty, and let's say you didn't properly know what the real consequences were, and so we go back to court and we get, for example, a particular crime reduced. Okay, the sentence reduced, what's called nunc pro tunc. So from the beginning, when you pled guilty, and let's say it's reduced to 364 days. Well, in that respect, now you don't have a felony. Okay, you have a misdemeanor. Okay, a significant misdemeanor, but nevertheless, you don't have a felony. So there's ways of even if you have a criminal history, there's ways of working around that so that you would ultimately qualify. Now, the next part of that is a significant misdemeanor offense, and they have defined certain items that are considered to be a significant misdemeanor: domestic violence, burglary, various firearm offenses, drugs, and unfortunately for many people, a DUI. So the reality is, in other parts of immigration where, through adjustment or cancellation or, a variety of different other parts, a DUI doesn't necessarily affect one's admissibility. For DACA, a DUI gets you out. Okay, that's unfortunately a specifically and individually listed significant misdemeanor offense. So as with the criminal relief, which I was talking about before, you might be able to do that as well. For example, if you have the DUI. Now, the question is, with DACA, whether you can do an expungement, and whether the expungement would then still be considered to be a conviction for DACA purposes. And for other parts of immigration, for sure, expungement has no effect. But for DACA, possibly expunging may help. Now, the next part is 3 or more non-significant misdemeanors. And what do they consider a non-significant misdemeanor? Well, and by the same token, what do they consider a significant misdemeanor that they haven't specifically listed? Well, basically, if the sentence is more than 5 days, okay, they can go and consider that to be a significant misdemeanor. So if you have traffic tickets, if you have infractions that do have less than 5 days and are considered a misdemeanor and not an infraction, for example, driving without a license type thing, if you have 3 of those, then that's going to kick you out of this as well. So again, with the criminal part of this of DACA, there are several things that can be done, including again the criminal relief. But then, if it comes to my office and I look at it and analyze it, there may be ways to argue that, number one, it's either not a conviction or it's not a significant misdemeanor. There's ways of trying to work it so that you would qualify. Okay, and then the other and last element is that you have been under 31 years old on June 15th, 2012. So there was some issues before as to whether that meant whether you were 30 and that kicked you out, whether the date as of June 15th, 2012 was set in stone. So they've issued some more qualifications on this matter and made this fairly clear as well. So this is one of those items you're not really going to be able to work around. So, if on June 15th, 2012, you were under 31, then you can go forward and we can discuss whether you qualify for this particular relief or not under DACA. But if in fact you were over 31 years old on June 15, 2012, and unless your birth certificate was incorrectly dated, you're not going to be able to go forward with DACA. So that basically is a concise type description of what is needed in order to qualify for DACA and how to proceed on this matter. Now, there's some other issues that you need to be aware of. I have a lot of people that come into my office and they say, well, let me try to put it together and file it, and if they don't approve it, then then I'll come back to you and we'll see what we can do. Well, they have made it clear, they being immigration, that there are, with very limited exceptions, there are no motions to reopen, no motions to reconsider, no avenues of appeal for these matters. So that makes it extraordinarily important that if you're going to do a DACA application and have it done, that it needs to be done right the first time. It is your burden to prove that you qualify for DACA. It is not their burden to grant it. So if any one of those elements are not properly documented and not properly submitted, if the forms are not filled out correctly, if it's not submitted to the proper lockbox, of a myriad of different things, if it's not done properly the first time, then and it's denied, then that's it. You've lost out. You're not going to be able to get under DACA. It's unlikely that you're going to be able to go to an attorney afterwards and say, oh, I thought that I had it right. I thought that I did item 2 correctly. I didn't know that you had to do this or that, and in my mind I submitted what I needed to. It's unlikely that that attorney is going to be able to prepare a motion to reopen and submit the proper evidence and make a stronger case at that time. So all the more important why you have to make sure it's done right the very first time, which is why I would suggest, since this is such an important program and since the benefits are so good, that you come to an attorney's office, give me a call, give you a consultation, and have it done right from the beginning. Okay, so that you're not in that position where you wished that you brought it first to an attorney who knew what they were doing and then submitted it. Okay, so don't put yourself in that boat. Now, the work permit, once if it's approved, the work permit will be issued for 2 years. So that's great. You won't have to go back and renew it after a year or 18 months. It'll be issued for 2 years. Another question that arises is whether or not you will be able to leave the United States and come back if you get on DACA. Well, the current discussion and situation is that you will. You should be able to get advanced parole once it's approved and then leave and come back. But there are some issues as to whether if you do, the 3 to 10 year bar kicks in, if there's other grounds of admissibility that kick in, and that will have to be discussed on a case-by-case basis, but at least the initial outlook is that it will be good and available to apply for the advanced parole and the permission to leave. And so in this regard, as you can see, there are quite a few elements that need to be satisfied. There are significant documentary requirements that will need to be done. You obviously can't just send it in and say, oh, I came when I was 15 and I've been here for 5 years. They want obviously proof of everything. They have listed some specific items that need to be submitted with these applications. So what I would suggest, if you think you're under DACA or if there's any little possibility, give me a call and I'll be happy to help. One more item is they have specifically stated that they will not use the information contained in DACA applications to put family members into removal proceedings. So that obviously means parents, most likely. So, if your mom and dad are here illegally and you're afraid if you submit a DACA application, they're going to go after your parents, we essentially have the information that they will not use DACA information to go after family members, which is a good thing that we've been waiting to hear. So we'll do more on the coming videos, but do give me a call, set up a consultation time.